All right, Mr. Voida, we could call People versus Kyle Knott, file 23-93254 FH. And looks like this is here for a docket call, motion to quash, looks like a show cause to handle as well. Probably just in terms of logical progression, let's start out with your motion to quash. I did review your motion in brief and the prosecutor's response, and I did review the transcript of the preliminary exam. So, Mr. Voida, go ahead and argue the motion.
Thank you, Your Honor. And given the fact that the court has reviewed my brief, I'm not intending to regurgitate that at this point. The issue here is one of obstruction. And you have to decide in deciding an obstruction issue whether there was a knowing failure to comply with the lawful command. Now, there are two elements there: lawful command and knowing failure. And I'm going to take those in reverse order and start with the lawful command issue. And that takes us all the way back to Terry v. Ohio. Was there a reasonably articulable suspicion of criminal activity? And the court looks at the totality of the circumstances in making that decision. Here, police officers saw a truck with two people inside leave the Nighthawk bar around 3 o'clock in the morning, stopped briefly in the roadway, then pulled ahead and backed into a nearby driveway. Two occupants got out and ran into the woods. Now, at that point, when they ran into the woods, there was no stop, there was no command, no lights, no sirens, no detention.
Agreed. So my first question to you is, what do you believe that a reasonable officer should do when faced with that situation? Is it your position that they should say, oh, that's odd, and drive off?
I guess
or do they have a reasonable suspicion to investigate that unusual suspicious behavior to see what's going on here?
But it has to be suspicious, reasonably suspicious behavior that's attributable to criminal behavior.
Right, but it doesn't have to be, because this often comes up, and attorneys try to tie that to like a specific crime.
Mm-hmm.
So a police officer doesn't have to have reasonable articulable suspicion that you have violated section whatever of whatever code. They just have to have some articulable suspicion that criminal activity is afoot, right?
Right.
So the U.S. Supreme Court case, Illinois v. Wardlow in 2000, said a suspect in a suspicious situation there was being in a high crime area, coupled with his flight from nearby police, gave the police reasonable suspicion to justify an investigatory stop. Why wouldn't Illinois v. Wardlow control it here?
Because we simply have running into the woods as the factor. There's not that high crime area. What we have is two people in a vehicle late at night to get out. There's not an additional factor there. And so I think if you were in a situation, and if you wanted to add another factor, it might be driving away from a bar in the early morning hours. Well, okay, that gives reasonable suspicion of potential operating while intoxicated. And there I go trying to tie it to a specific offense. But I can't think of any other offense that might be in play here, other criminal activity that might be in play here. And so if we're talking about something like an OWI, that certainly would give suspicion as to the driver, but not as to the passenger. I don't see any other factors that point toward criminality that would point towards someone that's a passenger under the circumstances that are present in this case. That's where I struggle, Judge. And to be clear, the people seem to concede that point. They say in their argument that the officers that evening had more than sufficient cause to at least make inquiry of the driver of the white Dodge. Well, okay, but my client wasn't the driver. How do we know that? Well, car wasn't registered to him. They didn't find keys on him. And here's what's more important. Once the officers tracked him down and detained him, there's nothing in the record to suggest that they did any sort of OWI investigation. They took his PBT at the jail when they booked him, and they found out that he was drunk. But there were no field sobriety tests, no roadside PBT, no data master, no OWI arrest. And if you look at the information, there's no OWI charged. Nobody thought he was actually driving this vehicle.
One thing that wasn't clear from the transcript, and I don't know if it's on the record, and I just didn't catch it, was the other occupant of the car ever caught or identified?
No.
Oh,
Nor
but
charged.
they did see two people leave the car.
Correct.
So we caught one, but one got away and they don't know who it is.
Right.
Okay, they might think they know, but okay,
Right.
okay. Continue.
At any rate, it's my position that that one factor, suspicious running into the woods, was not enough to meet that standard that the Supreme Court articulated. If you had additional factors, those additional factors would have to be relevant to my client, who was the passenger in the vehicle, and I don't think there are any such factors present. But even assuming that you get past the lawful command stage, there has to be some evidence that there was that it was knowingly disobeyed, that lawful command was knowingly disobeyed. And I go through in my brief a lot of factors at play here. But as you read through the transcript, the officer describes the person running or people running, because he couldn't say who he was specifically chasing, as having crashed through the woods. Now that carries with it a certain volume, and it's not quiet. The person who's crashing through the woods is striking things, stepping on things, making noises that might make it hard to hear. In most cases that I see for resisting and obstructing, there's a clear understanding of a command. The lights, the police lights are on, the sirens are on. The person responds to an officer who says stop. There's eye contact between the officer and the defendant, and then the defendant runs away. There's physical resistance of some sort, not complying with handcuffs or something along those lines. Here we have a command. We pose to the court that it's not a lawful command, but if you decide that it is, it's a lawful command. And we don't have any evidence that my client heard the details of that command and knowingly disobeyed them. There's just nothing on the record to suggest that.
Well, I mean, aren't I supposed to, on a probable cause standard, make reasonable inferences from those facts? So your client admitted to the police that he knew that he was being chased, and he heard the yelling and the flashlights, and so he said he was being hunted like a deer. Is that enough to infer, to let the jury sort this out? I mean, I'll admit to you, this R&O charge seems like a fairly thin read. As I kept reading the transcript, I kept thinking, okay, and then what? And then what? And like, I'm expecting they're going to find drugs on him or something, but nothing. So they don't find any contraband. There's no criminal activity that he's charged with other than the mere running. And I got to admit, when I read it, I felt a little deflated at the end, like, that's it. But on my review of the bind-over decision, I have to find that there's an abuse of discretion. And aren't these enough facts to draw an inference that he heard the police tell him to stop and he didn't stop?
I don't know if it's enough. He certainly can find, you don't even need to draw an inference that he heard someone yelling. I don't think there's enough here to say that he could distinguish what was being yelled, because there's no evidence that he responded in any way. If the officer had observed him to pause after hearing it and then continue to run or something like that, I think we'd be at a point where you could draw that inference. We're operating in the dark in more ways than one of them very literal in this case. And I agree with you that it's a thin read. I think it falls on the abuse of discretion, too thin to proceed to a jury read. Okay, but that's where we're at, unless you have any other questions.
Okay, no, thank you, Mr. Vance, find your response.
Judge, I laid out my argument in my brief. I appreciate the court reading everything. I think if you look at the overall facts of the situation, you're 3 in the morning, car pulls out of the bar parking lot at 3 in the morning. When the deputies turn around and go down the street that the car is on, the car stops right in the middle of the lane of traffic. And I know it's thin, but clearly that's impeding traffic, number one. When the deputies start pulling closer, the car turns around and goes on a side street that comes in on that road at an angle, then backs up over a snowbank and into the driveway. The argument here is that the area was lit by a street light and a light from the bar. They're going to mark the patrol vehicle. Deputy McClellan states on his testimony that when their car is stopped by yet another person who wants to come up and talk to the driver, they're close enough with the side view that anybody in the truck should have seen it was a police vehicle. Then they notice someone from the driver's side get out in a hurry, almost fall down, and then take off running. I don't think it was clear that they ever saw the second person run from the vehicle, although he does see two tracks in the woods. He testifies that he's anywhere from 50 yards in the woods to at some point even closer, yelling in a loud outdoor voice numerous times to stop. There's an argument here certainly to be made. It may be circumstantial, but there's certainly an argument, a reasonable inference to be drawn from those facts. And the person continues to run and evade the police until he's finally caught by another officer. So we think there's enough for.
Okay, thank you. Any rebuttal argument, Mr. Boyda?
Briefly, I would note that at page 18 of the transcript, and I'm looking for the specific line here. The officer agrees, and it's lines 2 through 4, that there were 2 people in the woods. So it's in response to my questioning, but at any rate, he admits that there were 2 people in the woods. That's to the extent that people have disputed that.
All right, well, defendants moved to quash the information. The court has to review this on abuse of discretion standard for whether the district court abuses discretion in finding that there was probable cause that the crime of resisting, obstructing police was committed and that this defendant is the one that committed it. The issue is whether the defendant knowingly disobeyed the police officer's command to stop while giving foot chase through the woods and whether that command was lawful. I find that there was probable cause that the defendant did commit this crime. He admitted that he was being chased and he heard yelling and seeing a flashlight chasing behind him. His actions in bailing from the car, whether he's the passenger or the driver, at 3 a.m. at a stranger's property in the winter, running into the woods, gives reasonable inference that he knew the police were present and he was seeking to avoid contact with them. So the district court did not abuse its discretion of finding probable cause that the defendant knew it was the police chasing him and ordering him to stop, and he failed to do so. The defendant also raises the issue whether the command to stop was lawful, arguing there was no reasonable suspicion for a Terry stop in that situation. But the behavior of the car's occupants did justify an investigatory stop. And it's always helpful. The Fourth Amendment touchstone is reasonableness. So it's always helpful to put yourself in the shoes of the officer encountering the situation and imagining what we expect them to reasonably do. So just imagine for a minute what might happen if the police ignore that situation. And perhaps then those suspects enter the home of the house that they just are running around by at 3 in the morning, but the police just took off. There'd be an outcry. Well, how come the police just left and now left this poor homeowner to deal with this situation? Or it's the middle of the night, in the middle of the winter. What if one of those kids who's probably drunk, and it turns out they were, trips and falls and dies of hypothermia in the woods? Then people would say, what the heck is wrong with the officer for not checking this out? I don't think it's reasonable to say the police, given what they encountered, had to shrug their shoulders and say, that's weird, and drive away. I think they were entitled to investigate the situation. And I think that's justified by the Supreme Court case of Illinois v. Wardlow, 528 U.S. 119 in 2000. There, a suspect's presence in a high crime area, which there was a suspicious situation, coupled with his flight from nearby police, gave rise to reasonable suspicion of criminal activity to justify an investigatory stop. Here, the defendant was present in a suspicious situation, not a high crime area, but a car stopped in the middle of the highway at 3 a.m. just outside a bar, then backing over a snowbank into a driveway. Well, then he fled on foot to avoid police contact. This justified further investigation. And I think a quote from the Wardlow opinion describes how we view these situations through a lens of reasonableness. The Supreme Court said this: in this case, moreover, it was not merely respondent's presence in an area of heavy narcotics trafficking that aroused the officer's suspicion, but his unprovoked flight upon noticing the police. Our cases have also recognized that nervous, evasive behavior is a pertinent factor in determining reasonable suspicion. Headlong flight, wherever it occurs, is the consummate act of evasion. It is not necessarily indicative of wrongdoing, but it is certainly suggestive of such. In reviewing the propriety of an officer's conduct, courts do not have available empirical studies dealing with inferences drawn from suspicious behavior, and we cannot reasonably demand scientific certainty from judges or law enforcement officers where none exists. Thus, the determination of reasonable suspicion must be based on common sense judgments and inferences about human behavior. We conclude the officer was justified in suspecting the suspect was involved in criminal activity and therefore investigating further. You know, it's not unlawful to try to avoid contact with the police. I'm not saying that you have to, police officers walking up to you, that you have to walk up and greet them. You can cross the street if you want, but that's a factor for the officer to consider in a fluid environment. And here, 3 a.m, bailing out of a car and taking off in the woods, he has to look into that. Admittedly, as I've said, this might not be the strongest case of resisting obstructing. I'm not sure what a jury would do with that situation. It's pretty clear. I don't see a whole lot there. I don't even know, but I have to be mindful of my role. I'm not the prosecutor. It's not my decision whether to charge the case. I'm also not the district court judge. It's not my decision whether to bind over the case. It's my decision, and I'm not the jury. It's not my decision whether to acquit or convict this defendant. It's my decision today whether the district court abused its discretion in finding probable cause. And here, I just don't think that was present. So these are factual issues for a jury to resolve. The motion to quash should be denied. All right, we also have looks like a show cause of some failures to test and some missed and late SoberLink tests. Mr. Knopf, it's alleged that you're in contempt of court for violating the conditions of your bond. Oh, and obtaining a new misdemeanor traffic criminal charge. You have the right to have a hearing on those allegations where your contempt would need to be proven beyond a reasonable doubt. You do have the right to the assistance of Mr. Voida at any such hearing. If I find you to be in contempt, I could jail you for up to 93 days or fine you for up to $7,500 or both. Also, if I believe that you're not complying with the conditions of your bond, I can revoke that bond. Mr. Voida, knowing the rights that he has and the penalties that he could face, do you want this set for a hearing?
Yes, Your Honor. I would note that with regard to the misdemeanor charge, that has been dismissed pursuant to a admission of responsibility to a civil infraction. I don't know that that's going to be in dispute, but nonetheless, we would ask for a hearing on all at this point.
Okay, we could set this, say, for October 9th at 9:40 for a docket call and bond violation hearing.
That sounds good, Judge.
Now, if there's, be in touch with Mr. Radzabon, whether he or you want to proceed to a contested hearing that date, you certainly can, but my intention would be, if neither one of you really want to do that, is just to continue to monitor, see if there's no further violations. We'll just kind of keep this tracking the case, and I'd like to not revoke his bond on the matter. So maybe you can consult with your client about what he has to do to comply with these conditions.
I certainly will, Judge. Thank you.
All right, so Mr. Knopf, we'll see you back here October 9th at 9:40 in the morning. Because there have been some issues with compliance on bonds, that'll have to be an increase. Okay, we'll see you then, sir.
Thank you, Judge.